Hey everyone, and welcome to this explainer. Think of today's session as your high-yield masterclass on how contractual duties actually end without full performance. Now, since your law students are prepping for the bar, you already know the basic architecture of contract law, right? We've got formation, performance, breach, and remedies. But what happens when parties just need to end a contract early? It gets messy. So let's master exactly how you get out of those obligations today.
Here's our agenda for today. We're going to cover discharging contract obligations, the pre-existing duty rule, accords and substituted agreements, assignment versus novation, rescission and account stated, and finally, we'll wrap up with key takeaways and terms.
All right, let's jump right into Section 1, Discharging Contract Obligations.
At its absolute core, the discharge of a contract obligation simply means terminating a party's legal duty to perform. You're officially off the hook. Unilateral discharge really only happens in two ways, through full performance or a valid tender of performance. Basically, if you do exactly what you promised, or you offer to do it unconditionally and the other side flat out refuses, you're discharged. Done. But otherwise, if you want out early, you're going to need mutual agreement, which brings us to the real villain of contract modifications.
Moving on to Section 2, the pre-existing duty rule.
Picture this scenario. A worker is halfway through a job and suddenly demands more money to finish, without doing a single bit of extra work. Does the law actually enforce that new promise to pay them more? It's a classic extortion problem, sometimes called the hold-up game.
The rationale here is a firm, resounding no. And the crucial point to remember for exams is that promising to do what you are already legally bound to do is not valid consideration. That's the pre-existing duty rule in a nutshell. But, the law always provides escape hatches. Under the common law, you can get around this if you add even slight new duties, or if you hit truly unforeseen circumstances. Oh, and if you're dealing with a sale of goods, the UCC Section 2-209 just throws consideration out the window entirely. For goods, modifications are binding as long as they are made in good faith.
Let's dive into Section 3, Accords and Substituted Agreements.
Okay, pay attention because this is a classic bar exam trap, the timing of the discharge. What is the difference here? Well, an executory accord merely suspends the original claim until the new performance actually happens. If the debtor breaches, the creditor can sue on the old contract or the new one. But a substituted agreement? That instantly kills the old deal the second it's executed. If a breach happens there, the old contract is dead and gone, and you can only sue on the new one. Ultimately, it all comes down to figuring out the intent of the parties.
Let's test this with a Socratic hypothetical based on a real, kind of gross 1958 insurance dispute over a fungus hand infection. The insured party is fighting for their monthly indemnity, right? And they just agree over the phone to take an $800 payout. So the question is the old claim gone immediately?
In the Goldbard case, the court ruled, no, it's not gone. There is a very strong legal presumption against a creditor just surrendering their existing rights for a mere promise of future payment. Without really clear intent or a formal writing, that phone call was just an executory accord. And here's the kicker. Under New York's personal property law, an unperformed executory accord is completely unenforceable unless it's in writing and signed. Because this wasn't, the original claim was never discharged, and the plaintiff was totally free to sue on the original policy.
All right, Section 4, Assignment versus Novation.
We really need to untangle these lookalikes because the crucial point here is liability. Assigning rights and delegating duties leaves the original delegator on the hook if the new party messes up. You are still the guarantor of performance. But a novation? That's a total substitution. It completely cuts the cord. It brings in a new party and explicitly releases the original party from all future liability.
So, let's say a lender hands your loan off to someone else. Can they just walk away from their remaining obligations to you, like releasing held-back construction funds? Are they totally free and clear?
The first American case gives us the definitive answer. Absolutely not. The original lender tried to argue that assigning the loan documents acted as a novation as a matter of law. Well, the Utah Supreme Court completely shut this down. A novation is never presumed. Delegating a duty simply does not equal a novation unless there is clear, unmistakable proof the borrower intended to release the original lender. Without that explicit release, the original bank is still fully liable.
On to Section 5, Rescission and Account Stated.
Even when parties agree to just walk away, things can still get incredibly messy. In the Copeland case, two companies hastily agreed to cancel a construction subcontract without prejudice. Sounds simple, right? Well, the plaintiff later sued for breach, but the court actually allowed perilled evidence, extrinsic evidence outside the four corners of the contract, to interpret what without prejudice actually meant to these specific laypeople. Because the evidence showed the defendant reasonably believed they were being released from all liability, and the plaintiff knew this, the mutual rescission effectively discharged all past claims for breach.
Now consider this scenario, and this is highly relevant to any of you future practitioners out there. If your lawyer sends you a massive bill based on a history of past transactions, and you don't say a word, have you legally agreed to pay that exact total?
Well, because attorneys are fiduciaries, the rules change. Courts note that the relations between attorney and client are so confidential that an attorney cannot rely upon the face of the agreement alone. Courts are highly skeptical of using mere silence to lock a client into a bill under the doctrine of an account stated. The attorney actually has to prove the contract is fair and reasonable.
The Old West case perfectly illustrates this dynamic. A law firm sued their client, arguing that keeping the bills without objecting created an account stated. Easy win, right? Wrong. The client proved they had previously complained about the fees being excessive. The court ruled that retaining a bill only raises a rebuttable inference of consent. The client's prior complaints totally shattered that presumption, which forced the attorney to actually go to trial and prove their fees were justified.
Let's bring it home with Section 6, Key Takeaways and Terms. Let's look at how unliquidated debt applies to settlement checks, because you will see this again. A liquidated debt is clear and undisputed. If you owe exactly $10,000 and you send a check for $8,000 marked paid in full, cashing it does not discharge the debt. Why? Because there's no consideration. But if the debt is unliquidated, meaning it's subject to a good faith dispute, cashing that exact same check creates a valid accord and satisfaction under UCC 3-311, completely discharging the obligation.
You've got to watch out for these testing traps. First, writing under protest or without prejudice when cashing a settlement check, it's legally meaningless. You cash it, you accept the settlement. Second, you cannot use the UCC Battle of the Forms to alter a full settlement offer. The offeror is the master of the offer. And third, if the original contract needed to be in writing under the statute of frauds, your mutual rescission usually needs to be in writing too.
Lock these final definitions into your memory right now. A valid tender of performance discharges your duties even if the other side refuses it. A material breach excuses the innocent party from performing. And a waiver is the intentional relinquishment of a known contractual right. These concepts really form the boundaries of when discharge happens unilaterally versus when it requires mutual consent.
So we've covered the architecture of discharge, from the rigidity of the pre-existing duty rule to the strict requirements of novations and executory accords. Now what's really interesting is applying this framework to the real world. When your future client wants to walk away from a deal or restructure a massive debt, will you know exactly which discharge method to use to cut the cord without leaving them on the hook? Keep these rules in your back pocket, and you'll be ready to navigate any contract exit out there. Thanks for joining this explainer.